Space.
Você ilumina o sol, você cria cor, traz a paz das estrelas, meu amor. Quero te ver brilhar, quero te ver sonhar, como a luz do sol.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Oh! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalwear, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalwear. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch, Monday through Thursday from 10 a.m. till 3 p.m.
Yes, sir. Apparently there's some confusion. He thought when he filed the motion it was automatic. So his motion to withdraw is going to be, this matter is going to be continued until jury review this Friday at 9 a.m.
His
motion to withdraw. Well, I mean, we also have the status, but if he's withdrawn, I mean, we got to deal with the withdrawal first, and then, but everything will be dealt with.
That's fine, Judge. Thank you so much for letting me know.
Okay.
Appreciate it.
Okay.
That's on Thursday?
That's Thursday. Okay. Mr. Harper?
I don't know where he is. He's right outside the courtroom.
Okay.
Yeah, he's I'm right inside the courtroom.
You want to go?
I will. Let's go, Your Honor.
Let's do it.
Has Ms. Farkas, have you done all of yours? Yes.
Okay. They got mine lined up already, sir.
What? No. I think we just have to. No, yeah. So we're switching up to just like you go.
Don't do this.
Rudy and I will figure it out.
What are we going to do?
I think Mr. Harper's respectfully requesting to go first, Judge.
Yes, sir. You've only got 2, so.
I'll be efficient.
Thank you so much.
You want fame for fame?
Judge, this is Brittany Fain before the court on 23 CF 2642 and 22 CF 1937. I'm not going to go over the entirety of the motion, Judge. Mr. Fain sort of has an issue with respect to the notice. I think there might have been an incorrect address involved. I think that Mr. Fain has filed some pro se stuff pertaining to that particular issue, but basically the court notice may have been sent to the wrong address. He was actually residing in a different address. And he was not aware of his April 10th court date, which is what he's stated to me. Additionally, specifically with respect to the trafficking counts in his new law case, 23 CF 2642, the bonds as such currently are $50,000 cash or professional. Mr. Fain is unable to secure his release given the amount of the bond. He's asking for the court to entertain reducing that to a more manageable amount so that he can fight this particular case on the outside. So he's asking for a reinstatement of his previous bond due to lack of notice, and he's asking for a reduction of his bond in the trafficking counts, Judge.
Mr. Lawson.
Well, Judge, I just would like to go over briefly with the court the facts of case 23 CF 2642. I'm sure this court has read the offense report. And I don't want to boil the ocean here. However, I think the facts are important. In this case, there was a car accident and a detective was conducting traffic to manage the scene when Mr. Fain drove his car at the officer. The officer had to throw his flashlight at Mr. Fain to get his attention because the car was flying at the officer. The officer had to jump out of the way. In this interaction, at some point, the officer asked Mr. Fain for his driver's license. Mr. Fain said, "Nope." That's the quote in the offense report. And this then drove off. And this started a chase that went down Lovejoy and throughout Mary Esther. I won't bore the court with the details of where all it went, but what I will say is that clearly there is a desire present not to be in police custody based on the fact that he ran, because when his car finally came to a halt, he jumped out of the car and was chased a ways before finally sitting down and rolling over and complying with police. And then, of course, I would bring up the fact that this is a fentanyl trafficking case, and I would remind the court that earlier today the court said this, and the state tends to agree that fentanyl is a scourge on our community. Judge, I believe that $50,000 is appropriate given the totality of what happened here, because you have a fentanyl trafficking case and then you have a defendant who fled in a vehicle, fled on foot, and clearly didn't want to be apprehended.
What was the issue? I'm still a little bit unclear about the issue that his notice got sent to the wrong address.
That's on the older of the two cases, Judge. 22 CF 1937.
1937. So what's the bond on that?
Mr. Fain indicates that might have been $15,000, Judge. Cash or professional.
So we no bonded him because he didn't show?
Yes, sir. There was a capias. He didn't show in April 10th of 2023. He didn't show. Capias was issued. Subsequently, he was arrested on the new charge that Mr. Lasco has explained. And what, if I may briefly just respond to that, Judge, the allegations with respect, actually to both of these are still pending. These are still pending cases, Judge. And discovery is ongoing with respect to the newest charge. We are just asking for the option of contesting these allegations on the outside, Judge, and a reasonable cash professional bond.
Well, and Matt, sorry.
So, as it relates to the $50,000 cash professional, that based on the new law charges, that court finds that's completely reasonable. So I'm going to deny that. But I'm on the 22 CF 1937. If he was no bonded, capias, based on sending the notice to the wrong address, then it seems that we should reinstate for that offense the $15,000. Unless I'm not tracking what you're saying, and I don't know if the state may disagree. But
the state would love to weigh in on this, Judge, because my understanding, and Mr. Harper, please correct me if I'm wrong, but he had this first case, and then he picked up a new law violation. So he might have been no bonded for a failure to appear. But if this court wants to reinstate bond, then revoke bond again because of the new law violation, the state would be fine with that. But I think that we're just really looking at.
The court would do that. It'll revoke the first case based. So he was out on bond on 22 CF 1937 when he picked up the new charges.
That's what I think I heard Mr. Harper say.
Is that correct, Mr. Harper? So your client was out on bond on 22 CF 1937 when he picked up the new charges.
He was out on bond, capias was issued, and then he got a new charge. Yes, Judge. That is accurate.
Okay. So while I agree with you that if it was the notice was sent to the wrong address and he was issued a capias, that's a mistake. So, but even if we withdraw the capias, I don't know if the state has made that, but the state would be asking to no bond based on the new law charge, revoking the bond, and the court would grant that. And the court is granting that. So that ends up with 22 CF 1937 being no bonded.
I understand the court's argument.
Okay.
Judge, my client is asking, I'm not sure procedurally how this works, but with respect to the capias, my understanding is that he's asking if the court would permit the capias to be withdrawn with respect to the old charge. My understanding is that it's been served, it's no longer should be active. He still has no bond.
I'll withdraw the capias. But I'm revoking the bond if it isn't already done based on the new law charges.
Yes, sir.
Okay. Thank you.
I think I'll make it practical. Judge, this is Larry Haas before the court on 23 CF 2856 and 23 CF 2671. And I apologize in case the court wanted to know, Mr. Fain, his case was already continued and he's set in June.
Very good, thank you.
Mr. Haas is here before the court on issue of bond. Essentially, right now, his bonds with respect to the trafficking counts are such that he's unable to secure his release. He has no history of any failures to appear. He was employed at the time of this incident. They are trafficking in amphetamine, which is set at $200,000, and trafficking in fentanyl, which is set at $300,000. Judge, those bond amounts are such that he's unable to secure his release. He is asking for a reduction in those to the $50,000 to $75,000 range so that he can hopefully work with his family to get him out and get him back to work to help support his family. And again, he has no prior history of failures to appear, and he was employed at the time, Judge.
Counsel?
Judge, the state would disagree and would ask that the bonds remain where they currently are. I know that Mr. Harper is requesting something in the $50,000 range, and we saw a case earlier on today's docket that was a fentanyl trafficking case, and that had $50,000. When the state went in and looked at the facts of this case to see why the bond was set so high, the best explanation that the state can provide to the court is that the amount of drugs themselves, as this court is aware after reviewing the offense report or the arrest report, was substantially more in this case. With regard to the amphetamine trafficking, it was 135 grams of methamphetamine. And with regard to the fentanyl trafficking, it looks like it was about 32 grams of fentanyl is what was alleged to be traveling in his vehicle at the time he was pulled over, amongst other narcotics, which he was also charged with. So, Judge, given the fact that the min-mans on these cases are so high and that these are first-degree felonies, I believe that the state would say that this is a proper bond.
Now, if I'm just looking at the charges on the docket today, the fentanyl drug trafficking says more than 4 grams, less than 14. I thought you just said there was 30 plus 32.
That's a great observation, Judge, and thank you for bringing it up. It appears that it was charged between 4 and 14 for some reason. However, the drugs, when they were weighed by law enforcement on scene, they came out to about 32 grams, and they were field tested, which isn't, admissible in court. However, it's the best law enforcement can do at the time, and that tested field positive for fentanyl when it was 32 grams. We've since sent these drugs off to the lab. I don't have that report back yet, but when it comes back from the lab, there's going to be a weight, and I certainly will adjust the charges based on the weight at that time once I can get the lab report back.
And Your Honor, my only response to that is that notwithstanding the state's assertion as to the weight, we can only go off of what he's currently charged with. And that's what he's currently charged with, Judge. And in light of...
I'm sorry. A lab report came back very recently, and it is 25 grams of fentanyl and 128 grams of methamphetamine. So I'll have to recharge that fentanyl count.
She's wanting to play out. She picked up a new charge.
I mean, What I was going to say is pending the return of the FDLE report, I would consider reducing it slightly if it was under 14. That does make a difference. But with the higher amount, and the state's saying they're going to recharge, there's no use in me lowering it and then immediately entertaining a motion to raise it again. That these are, the weights are significant, and they are both significant trafficking, so they are high. Normally I would entertain maybe 250 for the fentanyl and 100 for the amphetamine, but with the high numbers, I can't disagree with the state that it's the risk to the community has escalated because of the very serious amounts, and we've now got them tested by FDLE on top of it.
Judge, Mr. Haas is currently set for June 12th.
Very good.
And Mr. Harper, we sent that FDLE report to you.
Okay. I think that's all yours, isn't it, Mr.
Yes,
Hall?
Judge, if I may be excused.
You may. Mr. Gates.
Your Honor, next is going to be Amy Harrell. She should be number 32 on the docket.
Okay. Got it.
We have a plea agreement to be followed from Ms. Harrell. Your Honor, if I can have her sign it, please.
What's the defendant?
Amy Harrell's Ms. Sharpless's.
This is mine, sorry.
Ms. Harrell's before the court in 23 CF 2043. May I approach you? This will be a modification of Ms. Harrell's probation total in this portion. Okay.
Would you please announce the agreement?
Yes, Your Honor. Ms. Harrell will be admitting the violation before the court in 23 CF 2043. She was previously adjudicated guilty. We're going to modify and reinstate her probation. Count 1, which is the sole felony count, probation will be modified to drug offender probation for the balance of her supervision, curfew from 9 p.m. to 6 a.m., which can be modified by parole and probation for work purposes. Counts 2 and 3, which are misdemeanor, will be time served. $100 cost of prosecution, $150 public defender fee. Ms. Harrell must complete her requirements. There will be weekly UAs for the next 3 months of her supervision, and then will be once per month for the balance of supervision. Bless you. Defendant must complete her community service work rate at a rate of 8 hours per month until completed, and we're going to add the condition of buyout community service work as well, Your Honor.
That's the state's agreement, Your Honor.
Very good. So just point of clarification, the probation for the felony probation, it's modified to drug offender, but the term of the probation, I'm assuming, has not changed.
No, Your Honor, it's the same.
Okay, very good. Ms. Harrell, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, I do.
Okay, so ma'am, you heard your attorney state the terms of the plea agreement. I see those terms are in the written plea agreement that you've signed. Just want to make sure, have you read this closely?
Yes, sir.
And gone over it in detail with your attorney?
Yes,
I'm sure you had all your legal questions answered.
Yes, sir.
Yes? And because you're waiving some valuable legal rights, so I just want to make sure you're doing it freely and voluntarily. You're waiving the right to go to a trial, force the state to prove their case and all that,
Yes, sir.
in order to have a final resolution of this case, which is what we're doing here today.
Yes, sir.
Is that what you want to do?
Yes, sir.
You believe it's in your best interest?
Yes, sir.
Based upon that testimony, the court will accept the state's agreement. Right?
Yes, Your Honor, this is
The court will accept the plea agreement as written, and there was, as stated, previously adjudicated guilty on these charges. The court, as to count one, which is the sole felony count, or the sole felony of probation two, the court will modify and reinstate probation, not change the term, but change it's going to be modified to a drug offender for the balance of the supervision, and there will be curfew from 9 p.m. to 6 a.m. Can be modified by probation for work purposes. Counts 2 and 3 are both misdemeanor violations of probation. Those, you'll get credit for time served, and you'll be done with those. Okay, so it's just you'll be on probation for that single felony count.
Yes, sir.
Okay? Got the standard court costs and fees, of course, always. Complete the original requirements, and you'll have to submit to weekly UAs for the next 3 months, and then at least one per month after that. And you must complete the community service hours at 8 hours a month, and you can buy it out. That's a new part of the provision as well.
Yes, sir.
Any questions concerning any of this?
No, sir.
Okay, very good. Thank you very much.
Johnny Hill. Yes, Your Honor. Next is going to be Mr. Johnny Hill before the court. Should be number 33 on the docket. He's before the court in 18 CF 2511 and 21 CF 1038. We do have a plea agreement to be filed in his case. It's also going to address 24 CF 679, which is set for May the 16th, Your Honor.
Okay.
Making sure I have everything we need before I approach Your Honor. May I approach, Your Honor?
You may. Thank you. Could you please announce the terms of the agreement?
Yes, Your Honor. Mr. Hill will be entering an admission in 18 CF 2511 and in 21 CF 1038, pleading no contest and is charged in 24 CF 679. He'll be adjudicated guilty in all counts and cases. We're going to revoke and terminate his outstanding probation in the VOP cases, placed on a new term of 24 months of drug offender probation, and any misdemeanor counts and those that will be time served. $100 cost of prosecution, $150 public defender fee, and 18 CF 2511. Complete original requirements. Curfew will be from 9 p.m. to 6 a.m., which can be modified by for work purposes by parole and probation. And then 21 CF 1038, again, same terms. 24 months drug offender probation and felony counts, time served and misdemeanor counts. Standard court cost, $100 public defender fee, curfew again from 9 p.m. to 6 a.m., which can be modified by parole and probation for work purposes, complete original requirements. And in the new case, 24 CF, make sure I got it right, 679, Mr. Hill will be adjudicated guilty. Count 1, which is a felony count, he'll be 24 months of drug offender probation, 615 court cost, 100 public defender fee, required to do substance abuse evaluation within 30 days, and the recommended treatment in 60 days, 48 hours of community service work, maintain gainful employment, or complete 3 job applications per week. I think that is all the terms. If I missed something, I apologize, Your Honor.
No, you did good. I thought you missed something, and I was going to point it out to you, but on closer review, I realized that I had missed something and you had not.
Yes, Your Honor.
State an agreement. I'm sorry.
Your Honor, the state of agreement.
I'll be honest with you, I didn't have that written down at all. That was all trying to...
From memory, you're impressive. So, Mr. Hill, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Mr. Hill, you heard your attorney state in detail, off the cuff, your agreement, which the court was following with the actual written agreement, and I see you've signed that written agreement. My first question is, did you read the written agreement closely? Did you go over it with your attorney? Make sure you had all your legal questions answered.
Yes, sir.
And you understand that by entering into this, waiving some valuable legal rights, rights to go to a trial, force the state to prove their case, all that.
Yes, sir.
You'll have a final resolution here today. Is that what you feel is in your best interest?
Yes, sir.
You are entering this freely and voluntarily?
Yes.
Nobody threatening or coerce you to get you to enter into this? No. Okay. Based upon that testimony, the court will accept your plea. And as on the violations of probation, as well as the possession charge, the new law charge. Let me see here. The felony VOPs, there's two of those, and the new felony possession of controlled, they're basically identical and concurrent sentences. And the sentence is 24 months, basically revoke and terminate probation, and then a new term, 24 months. So each of those is going to be the exact same thing. They'll run together. So it's a total of 24 months. Drug offender probation, waive the cost of supervision. You've got a curfew from 9 p.m. to 6 a.m., which can be modified for work purposes, standard fees and costs. Those are all three of those. You also have two misdemeanor violations of probation and a new law charge misdemeanor. All those are credit for time served. Those are done based on your time you've already been in the county jail, okay?
All right.
So basically you're just running three concurrent drug offender probations, which all the requirements, you need to stay up with the probation closely so you can be successful with these. You also have the standard fees and costs, and of course with the new law charge, importantly, you've got to do the substance abuse evaluation and recommended treatment and maintain gainful employment or 3 applications.
Yes,
Okay.
sir.
Any questions?
No, sir.
Score sheet?
Yes, Your Honor, we'll file one later.
You do have 30 days to appeal this if you want to. Thank you.
Your Honor, next I think is going to be Mr. Jonathan Holcomb, number 34 on the docket.
Correct.
Hey, Jonathan. Good. Your Honor, one of Mr. Holcomb's violations is based upon a new law violation. It's my understanding that that is actually set for trial, at least review tomorrow with trial next week. If we can continue Mr. Holcomb's VOP pending that, my anticipation is depending on that resolution, we might be able to get this resolved.
I'm sorry, say that again?
So, Your Honor, there's a new law violation that's with our misdemeanor counterparts.
Okay.
We believe that that will be tried next week, so we're just...
I was wondering, because I was kind of thinking through yesterday, my trials, I didn't recall having Mr. Holcomb up for next
No, he's in front of Judge Schlechter, I do believe,
Okay.
and the anticipation is that it's review tomorrow with trial next week. Depending on that outcome, we should be able to resolve these cases as soon as possible.
I would agree with that.
Okay. So, you want to just come back here on my closest miscellaneous docket would be May 16th.
Yes, Your Honor. And that'll be perfect. That'll give you time to go out and get everything arranged with Mr. Holcomb, and we'll go from there, Your Honor.
Thank you. We'll continue these to May 16th.
Your Honor, I was able to locate his score sheet for myself.
Okay, thank you.
Very good. I have to say to you before I go out.
Thank you.
She was in custody, but
Your Honor, this is Mr. Kirsch before the court in 23 CF 1385. He's set for arraignment today. The state and I discussed a potential resolution. Mr. Kirsch is actually asking for 12-1 DOC. He would prefer to go to DOC versus county jail. Given the state's position, they need to speak with the victim before a resolution on the VOP. If we could set him for May the 16th or the 21st.
Judge, if I may.
Sure.
Would the court be receptive to the idea of bringing this defendant back on Thursday, seeing as we have...
Be here Thursday? He would be my only one, so I don't plan on coming.
Oh, I understand. I apologize, Judge. I was just trying to be proactive on getting a resolution done.
By anticipation, not much difference between Thursday and next month anyway for Mr. Kirsch. I know he'd like to get it resolved sooner than later. Steve, if I have a question, can you handle him on Thursday? Well, if we could do Thursday, Your Honor, if the court's inclined to do that on more than the day.
And that would give the state the time to comply with Mercy's law.
Okay, we'll continue this till 4/18.
Yeah, sure. My thinking that way, if we get him sentenced to DOC, he gets there quicker versus waiting.
Thank you.
Okay. I think that concludes my business for the court this morning. Thank you.
Judge, I believe that concludes mine as well. May I be excused?
Thursday?
Thank you.
I don't like to see you this afternoon.
Oh, I'll get Rachel.
Judge, I won't be here this afternoon.
I won't see you this afternoon.
Yeah.
Oh,
Thank
I checked
you.
earlier. You or Rachel,
I have
one of you two
coverage.
will get it for me.
I have my coworkers covering for me.
My body's here.
We'll make sure.
Your Honor, Steve Medina with Jenny L. Baker. May I give Ms. Baker a bit of information?
Sure.
And then I'll announce your cases.
Okay. I'll announce the cases while you're doing that. This is your cases 22 CF 2998, 23 CF 712, and 23 CF 713.
Your Honor, I'm sorry. I think, Your Honor, while I was talking to her, I apologize, Judge, but Jenny L. Baker before the court with Steve Medina, and I think Your Honor announced the case numbers.
Correct.
Thank you.
There were three of them.
Did that include the new law 24 CF 721 that's on the
No.
afternoon docket?
No.
Okay, so
So that's on the arraignment
right,
docket as
Judge,
well?
and I've talked to Ms. Baker, and I've spoken to Assistant State Attorney Giardina, and we're going to work out a global resolution that includes the new law, and we'll get that typed up over lunch. If we can hold, she was on the arraignment at 1:30 anyway, so we'll just keep her to 1:30, and we'll do a global deal then that's everybody's satisfaction.
Okay, hold on a second. I don't think I have her on my...
You know, Judge, I'm mistaken. She said that was May 16 arraignment. She's not this afternoon arraignment. I just saw AR and I thought it was this afternoon, but can we hold her at 1:30?
Why don't we just continue, we'll just hold these three cases over. If you can do a resolution, we'll do these three and the new law charge this afternoon, get it done.
Thank you, Your Honor.
As long as the new law charge has an information file, so that's the question.
It does, Your Honor.
Okay? With that, then I think we can.
Thank you very much, Your Honor. So we'll bring Ms. Baker back at 1:30-ish.
Okay.
Thank you.
Thank you.
Your Honor, I did not realize Ms. Byers was in custody. May I give her a bit of information?
Sure.
Your Honor, the state's offer, as I understand it, this is Steve Medina with Don D. Byers, 23 CF 341 and 22 CF 1606. And I think what happened was, last time she was in court, she was taken into custody, and Mike File didn't catch up to her situation, so I didn't realize she was in jail. But the state's offer is 12-1. At this time, I would like to have a denial entered. She probably wants a VOP evidentiary hearing, but I would ask can we do a 1 month continuance instead of longer than that? And I'll see if we can work.
That would be
the case out.
standard for the violation.
Thank
so we'll come back on May 21st.
Okay.
Now, her second case, 23 CF 341, that's the new law charge, right?
These are both violations.
They're both VOPs, Judge.
Because it has it listed as miscellaneous criminal on my docket. That's what.
There's nothing other than VOPs as far as I'm aware of. There was a new law that I think
that's
was
fine. I
in
just wanted to make sure
criminal
I'm
traffic court.
I just want to make sure I'm tracking it properly. Both of them are violations. Okay.
Yes, and then she has jurisdiction in criminal traffic court on a new law there, right? You haven't resolved that yet. Okay.
They're not resolving that until this is resolved.
Thank you, ma'am.
Okay.
So we'll
come back on May 21st, 9 a.m.
Right, and I think this is this Ms. Giardina's case
This
or
might.
is this Ms. Sharpless's case? Right, so Ms. Sharpless and I will get together and see if we can resolve it, but just so everybody's on the board here, is Ms. Byers is saying she doesn't want a jail or DOC sentence, so as her advocate, my abilities are limited to requesting an evidentiary hearing and doing a deal if there's a deal to be done. Doesn't seem there's a big deal to be done, so we may be seeking a VOP evidentiary hearing next court appearance if we can't work it out. Thank you.
And if you want to try and move the case forward, and you both the state and you come to the conclusion that you need an evidentiary, go ahead and schedule it up with my office.
Okay, thank you, Your Honor.
Okay, but if not, we're definitely coming back on 521.
Thank you, Judge.
Now we skipped over Jamari Bush. That's
yes. I don't think Mr. Bush is in custody, and I have no information as to his whereabouts, Your Honor. Jamari L. Bush, 19 CF 1059.
Was he properly served? The state attorney can look at that while we're handling the next case. Who is this, Mr. Medina? McCoy?
Yes, Judge. Let me pull Mr. McCoy's files, Your Honor. Steve Medina with Jiron McCoy. Is it Jirion or Jiron? Jiron, I'm sorry. His cases are 19 CF 2428, 19 CF 2629, 19 CF 2627, 19 CF 2628, and 19 CF 2638. And Your Honor, I've had some significant discussion this morning with the state. If we can continue his cases to the next VOP date, was it May 19th or around then? We may be able to reach a resolution.
May 21st.
I'm sorry, was that May 21st, Judge?
Correct, May 21st.
Okay, thank you, Your Honor. We're going to be getting some proof of his Louisiana jail and prison time for the state's consideration. Thank you.
And did we get whether Mr. Jamari Bush was properly served?
Your Honor, on 3/19, he appeared with Mr. Medina, and he was given this court date at 9 a.m. to appear, Your Honor.
Any legal objection to the capias, Mr. Medina?
I can't think of a legal objection. I can think of an ask to give me over lunch to see if I can reach out to him. I apologize.
I'm going to issue the capias, but if you found him over lunch, I'm sure I would reconsider it for sure.
Thank you, Judge.
Jonathan Newton.
Dr. Steve Medina with Jonathan L. Newton. Can the court find it on the docket? I apologize, Judge. 13 CF 1047. We have a VOP plea agreement, Your Honor. The score sheet will be provided later by the state attorney's office, but having discussed it with Assistant State Attorney Giardina, it's 10.4 points score sheet, so he's nowhere near to scoring prison. May I approach with the agreement, Your Honor?
You may.
Thank you. Oh, Judge, I'm sorry, he's got to sign it.
Okay.
Didn't mean to give the court whiplash, Judge. There. Thank you. I'll do it. Thank you. And Your Honor, I'm going to pull it up on my phone. I already gave a copy. Probation made a copy over there.
Thank you. Would you please?
Yes, Judge. I'm just pulling it up on my phone so I can. My memory is not as good as Mr. Gates's, so.
Well.
Your Honor, in 13 CF 1047, Jonathan L. Newton will be resolving the VOP through the following agreement. He was previously adjudicated guilty. He'd be admitting to VOP. It would be credit for time served, $100 VOP fee, $150 PD fees, revoke and terminate the supervision. The outstanding monetary obligations would go to collections or lien 6 months after release. And that is the agreement, Your Honor.
And that is the state's agreement, Your Honor.
Very good. Mr. Newton, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Obviously, a pretty straightforward agreement and simple. You're admitting you've already been adjudicated guilty, admit the VOPs, credit for time served. Of course, they always get in your pocket for some additional fees and costs. And then you'll have 6 months before it goes to collection. If you can pay it before, then it'll avoid you going after your driver's license. Okay. So is that your understanding of what the agreement is? I see you've signed it.
Yes, sir.
And you understand that by entering this will be a final resolution of your case here today. You're waiving the right to go to a trial.
Yes, sir.
You believe this is in your best interest?
Yes.
Okay. The court will accept your plea, and in the admission of the VOP, you're being sentenced. The actual technical sentence is credit for time served. And you'll have the fees and costs and revoke and terminate all supervision. And then the monetary obligations will go to collections and liens 6 months after you get out. Any questions? Okay. Thank you. Good luck.
Thank you, Your Honor. Good luck.
Mr. Medina, I think that's a wrap for this morning, isn't it?
I believe so, Your Honor.
Okay. Very good. So we will adjourn until 1:30?
Yes, Your Honor.
Yes, Your Honor. Thank you.